Good afternoon. Your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
It's safe for sure, sir.
Before we even get into the courtroom audio, let's set the stage here because this case is a perfect example of what happens when confidence completely outpaces comprehension. Today's defendant isn't just dabbling in sovereign citizen talking points, he's fully submerged, convinced that legal reality bends to whatever version of the law exists in his head. What makes this situation especially dangerous isn't just the confusion, it's the certainty. This is someone who genuinely believes the court is wrong, the state is wrong, and everyone else is just too ignorant to understand his logic. Meanwhile, the consequences are very real: missed court dates, bench warrants, escalating bond amounts, and the very real possibility of spending months behind bars. As this hearing unfolds, pay close attention to how the judge repeatedly offers him lifelines, legal counsel, explanations, even patience, and how every single one of those opportunities is casually brushed aside. This is less a legal defense and more a slow-motion self-sabotage.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
This is where things start going downhill fast. Failing to appear in court isn't a technicality, and it's not something the court just shrugs off. It's one of the quickest ways to lose any goodwill you might have had. The judge isn't speculating here, the record is clear. A scheduled preliminary hearing was missed, and that absence triggered a bench warrant and a bond forfeiture. What's important to understand is that the court doesn't care why you think you didn't need to show up. Intent doesn't override obligation. The legal system operates on schedules, procedure, and compliance, not personal belief systems. And from this moment forward, everything gets harder. Higher bond, less trust, and significantly less patience from the bench. This is the cost of treating court appearances like optional suggestions instead of mandatory orders.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear, and on May 5th, we did not appoint any counsel. I don't show an actual waiver, and the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay, well,
Okay.
Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right, can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There's
Yeah.
there is no defendant in the. I'm the defendant in the case. Am I the defendant in the case?
This exchange perfectly captures the irony of self-representation. The judge lays out in plain language what an attorney could actually do: negotiate charges, suppress evidence, reduce exposure, maybe even get the case dismissed. And the defendant's response is essentially, "I don't see the point." That's not independence. That's misunderstanding the battlefield you're standing on. Judges are required to make sure defendants know their rights, not that they use them wisely. And here, the court goes out of its way to explain that if money is the issue, counsel can be appointed. This isn't the system being unfair. This is the system bending over backward. Once he insists on representing himself, every mistake from this point forward is on him alone, and the court will not rescue him from the consequences of his own decisions.
There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges: possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime. No victim.
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim that
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself, or do you wish to have an attorney representing you?
I will represent myself.
Now we see the procedural side collide with sovereign confusion. The court isn't arguing philosophy here, it's trying to document a waiver of counsel properly. This is basic due process. Courts must have a clear record that a defendant knowingly and voluntarily gave up the right to an attorney. Without that paperwork, convictions can get overturned later. But instead of understanding this as a safeguard, the defendant spirals into semantic arguments about labels and status. The irony is that these protections exist for him, yet he treats them as an attack. This is a recurring theme in sovereign-style arguments, rejecting legal protections while simultaneously demanding legal recognition. You can't have it both ways, and the court isn't going to entertain circular logic just because it's delivered confidently.
You've got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you, and that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on
I'm asking questions. I'm really asking questions.
October.
Trying to understand.
This is the classic sovereign citizen talking point, and it's one of the easiest to dismantle. Crimes don't require a bleeding victim standing in front of the judge. Drug possession, driving while suspended, and public safety offenses are crimes because they create risk, not because harm has already occurred. The judge's school zone analogy is spot on. Laws exist to prevent tragedy, not to wait for it. This argument fails in every jurisdiction, every time, and courts have rejected it for decades. Yet defendants keep repeating it as if repetition might magically rewrite statute books. The frustration you hear from the bench isn't impatience. It's the exhaustion of explaining settled law to someone who refuses to accept it.
Mr. Walker, your case is being set on October 10th at 2:30 in front of myself, and that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be able to have access to certain legal things to be able to put my case up.
Here's the moment where the court's tone shifts decisively. The judge isn't confused, he's done indulging nonsense. When a judge says, "I'm not going to play this game," that's not an insult, that's a warning. The court has a docket, serious charges, and limited tolerance for bad faith arguments. Meth possession isn't minor, and neither is repeatedly failing to appear. The judge spells out the stakes clearly, sets the next hearing, and locks in the bond. This is procedural control being reasserted. From this point on, theatrics don't help, philosophical debates don't help, and sovereign slogans don't help. The case is moving forward whether the defendant understands it or not.
I believe they've got a law library there at the jail. I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like he failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused. Thank you.